Welcome to Case by Case. This is a podcast brought to you by Callum Chain and Luke Zadkovich from ZFZ. How are you, Callum?
I'm good, Luke. How are you?
I'm great. We're talking about a very interesting case today, the case of the MT Polar, and I'm excited.
We're in the Supreme Court, so hard not to get excited.
Supreme Court, unanimous decision given by Lord Hamlin with Lord Hodge, Lord Lady Rose and Lord Richards agreeing. This is the judgment of the Herculito maritime and gun war case, as I said, relating to the vessel, the MT Polar. Citation for this case is 2024 UK SC 2, an appeal from Court of Appeal decision with citation 2021 EWCA Civ 1828. Judgment was given down a few months ago on the 17th of January 2024. Super interesting case in some ways. So, some of it, I could say, some of the points don't come up that often, I think, in practice. But the points that do come up here throw up some really interesting issues for practitioners in shipping law, practitioners in insurance law, and really getting into this concept that two contractual parties can agree to an insurance solution in the event of certain events, rather than look to each other for liability on a breach of contract basis. So it's this kind of whole world, which I think's fair to say is a expanding world, although in this case, the courts, I think, put some limits on that. But it's an area, at least in the development of the law, that when I first came into it, all those years ago, wasn't the type of argument you would see come up all that often. But it has appeared here and there in some different cases, and not just in shipping cases, also in landlord-tenant cases and in construction cases. So, yeah, what do you make of it, just the kind of headline level, Callum?
I remember well reading the Ocean Victory decision, the Supreme Court decision in the Ocean Victory, where this point, a similar point to this, was discussed at length, and there was dissenting judgments. I think it was Toulson and Sumption, who both were looking at this from opposite sides of the coin. I remember at the time being fascinated by this question, the question of when do the parties to a contract create a code where effectively saying that recourse for some loss is to be dealt with by the insurer, and effectively the insurer doesn't have the right to then bring a kind of subrogated action against one of the other parties. This case is on a very similar point. So I found it a really interesting case. I really enjoyed reading it. It clarifies the law a lot, particularly for situations where you don't have a kind of joint name insurance. It was also surprisingly timely, given that this is a case that relates to a hijacking or a vessel seizure by Somali pirates in October 2010. It was interesting that there's quite a detailed discussion on the difference between the level of risk kind of anticipated by the parties at the time of contract versus the level of risk that the parties experienced at the time of performance. Although this happened, nearly 15 years ago, the event in question, this judgment was handed down right when there was a big escalation in the Houthi attacks that we've continuing to see. It became a very interesting judgment from that perspective, and I read it in detail at the time to be able to advise properly on those cases about whether there's this difference between the amount of risk accepted by a party when they signed a contract and whether that risk had changed significantly at the time that they actually had to perform under the contract.
Yeah, some really interesting points in there. And, those Red Sea issues that kind of flared up over the new year really kept us busy. And you in particular, Callum, I know you had a lot to do on all of that. So, yeah, quite right to note how timely it was. Going back to the Ocean Victory case, I think there is a real difference in a way between that case and this case, although it's, obviously in the same area on the same point. And that is this concept of joint insurance or joint named insurance, and insurance that's intended to cover situations between two unrelated parties. I think there's quite a difference there. And when you think about it, well, at least when I think about it, I conceptually think of those as quite different. And one of the issues that I wanted to touch on today as we get into it. And it's not explored all that much in this decision. Where I have troubles with finding a quote unquote insurance solution between two unrelated parties. If those two unrelated parties who are counterparties to a contract, but unrelated in the sense that they're not affiliated, they're not part of the same group, there's an issue that happens that would fall under an insurance policy that has been taken out. If the owners want to pass on the liability to charterers for, lost record reasons, or charterers, more particularly, charterers insurers that may have to pay out under this policy, want to subrogate and step into the charterer's shoes and then sue someone else down the chain, the insurance solution takes that away. Now, it's subject to contract and all of that, what the contract actually says, and that's a super important part of this whole judgment. But the area where I've got difficulties with, two unrelated parties finding an insurance solution is that the subrogated insurer wanting to step into the shoes of the charterer then can no longer pass that liability on down the chain. And that, to me, seems like, from an insurance perspective, and you'll recall that I started my legal career advising insurers in all sorts of portfolios. In a rating the insurance risk assessment, that would change the premium massively if they are unable to pass on that liability to, sub-charterers for a unsafe port, or pick your example. And it comes through ultimately in this decision where there needs to be some guardrails on this. And I think finding an insurance solution is typically going to be a rare scenario.
Totally agree. And I had the same thought, particularly on pricing the risk. It becomes a risk of a very different nature if you lose your right to recover it. There are a few interesting points in this case, even though really the case is dealt with on the first of those interesting points. So if maybe it's a good point to discuss some of the background.
Yeah, I think we can probably do a pretty highlight on this one and kind of get into those legal issues.
So you have a charter, which is between the owners, Herculito Maritime Limited, and the charterers, Gunvor International. There's then a series of bills that are issued under that charter party. The parties to the bills are actually quite interesting here, and there's a gloss on this, which is not really mentioned in the judgment, but I'm interested in your take on this, Luke. The bills are issued to the order of BNP Paribas, and the shippers are a party in the Rosneft group. But the bills are then endorsed on so that Gunvor become the eventual lawful holders. I'll come back to that in a second. The argument that Gunvor ultimately seek to run is that their liability is limited because there's this insurance solution between owners and charterers, which means that as between owners and charterers, they've agreed that they will put up some kind of insurance to protect themselves against certain risks, including the risk of piracy and payment of a ransom. And therefore, as between owners and charterers, the agreement is any liability that you face in the kind of orbit of those risks is dealt with by this insurance solution. It's not a liability that the parties can address between the two of them. The insurance pays out and that's it. The holders of the bill, Gunvor, are saying this protection should also be extended to us as the holders of the bill, because that term is incorporated into the bill, and that term where it's found in the bill can be read as meaning as between cargo interests, or the holders of the lawful holders of the bill of lading, and owners. So effectively, this insurance solution gets passed down. The reason the parties are quite interesting is that the charterers are Clear Lake Shipping. Clear Lake is the shipping subsidiary of Gunvor. So this becomes particularly kind of interesting to Gunvor as a group, because they're effectively the ones paying for the insurance as charterers. And then they're the ones who are facing the claim from owners on the basis of the thing that the insurance that they've bought has already paid out.
Yeah, exactly. And so the first part of the judgment deals with this insurance solution concept and how that works, which I think we'll get into next. Just to kind of highlight this, and I say this now because it kind of fits within the factual understanding, is that there's also some really useful paragraphs in here, or commentary on incorporating charter party provisions into bills of lading. And it's always good to get a Supreme Court decision on some of those basic principles and have them all pulled together So we'll come on to that as well. But, incorporating charter party provisions into bills of lading is something that goes far beyond this narrow case in that way. So interested to get into that and hear your take on those points as well, Callum. But dealing first with the insurance solution, what did you make of that?
The key clause, there are a couple of key provisions. The first is this kind of bespoke, quote unquote, Gulf of Aden clause. This is the third paragraph of that clause. Any additional insurance premia, including but not limited to those in respect of H&M, crew, P&I kidnap risks and ransoms, crew bonuses, which to be in accordance with the international standard, shall be for charterer's account. Max $40,000 United States dollars for charterer's account for any additional insurance premium, except for crew bonus, which to be max $20,000 US dollars for charterer's account. In very broad strokes, the argument is that, again, as between owners and charterers, there's an agreement here, which is if we do this thing, so if we transit Gulf of Aden, then as between owners and charterers, we've agreed that there will be additional insurance put up, that charterers will pay for it, and that insurance will be what owners are entitled to in the event of loss of the type insured. So the argument from charterers is effectively, if we're paying for this insurance, it doesn't make sense for us then to also face a claim from owners under the charter party to be reimbursed in some way for the thing that we've already insured them for. On its face, that's a reasonably compelling argument, I think. Taken at first blush, I think when you look into it in detail, it's actually not that compelling. But taken at first blush, I think that I have some sympathy with that argument, which is effectively, we've paid for the insurance, you have this insurance, if something goes wrong, the insurance is going to pay out, then you should look to the insurance. You should not look to us.
That is this concept of an insurance code or an insurance fund that has been set up by the parties, which is the exclusive remedy for those parties in the event of that type of issue arising. And what's interesting about this case is it's the first case, at least before the English courts, in which there has been this argument for an insurance code or fund in a voyage charter. And then, if so, because it was the voyage charter that was incorporated in the bills, if so, does that insurance code also form part of the bills of lading themselves? And so the court then went through a process where it explored the few decisions that there have been on these insurance code cases. There's the Evia number 2 case, which is a key one. And as you noted at the outset, Callum, there's obviously the Ocean Victory, and that's the most recent case to deal with this by the Supreme Court. And there's some really useful sections that deal with the Ocean Victory. In that case, ultimately, the case turned on the unsafe port warranty point, but in any event, the Supreme Court in the Ocean Victory went on to comment on the insurance code. And in that case, where that was in the context of a demise charter, not a voyage charter. As you and I and many listening in will know, a demise charter is often put up between parties who are part of the same group, where you have the registered owners as one entity and the demise charters as a separate entity, but for finance reasons and liability reasons and other reasons, they're in separate entities, but they take out joint insurance. That was joint H&M insurance for the total loss of the vessel, the Ocean Victory. And in that case, there was an insurance solution where owners and the demise charters had agreed on an insurance solution rather than on liability between themselves. And I think what's one of the reasons why the court starts there in the analysis is because that was one of these joint names insurance scenarios. And this is where it's common to find an insurance solution. The court goes through that, through the Ocean Victory, and then moves from there to say, well, okay, how does it arise in other cases? And that's when the court comes on to the Evia 2 to look at, I think, probably the clearest shipping example of where the court looked at potential argument around an insurance solution that did not involve parties in the same group, and then went through the indicia in the Evia 2 and sought to see whether this case was analogous with that or distinguishable from that case?
It's like a point of principle almost. This kind of decision on this insurance point, because it is very sensible on both sides, and you can see through the case law that the serious top level law lords have had differing views on this. It's a who's who of kind of top level contract law. When you look through this judgment, the kind of names that are being referenced in the discussions, and in a way the disputes between the judges, not disputes, but kind of the contrary views. As I say, you've got Toulson and Sumption finding differently in the Ocean Victory. You've then got Roskill and Bingham with opposing views. It's almost one of those ones where there's no wrong answer. I almost found that looking strictly at the EVA number 2 and kind of applying this menu of, does it do this, does it do this, does it do this, slightly takes away from just the fundamental question of, do you think in this situation there's an intention for there to be a recovery against an insurer only, or does the claim remain open even though the charterer in this case has paid for the insurance to cover the loss that they're now asked to pay against? I found it very interesting, and as I was reading through, it's one of those judgments where as you're reading through, you see an argument for one side and you think, yep, that is a very, very strong argument. I'm completely sold. Then the next page, you see the argument for the other side presented, and you go, that makes perfect sense too. Where this really kind of struck me was the Lord Roskill comments in the EVA, effectively talking about the result of there not being an insurance code, and saying the time charterers are to repay to the owners the premiums for the extra insurance, including extra war risk insurance premiums. But if the dangers against the risks on which they have paid those premiums materialize and cause loss or damage to the ship, then the war risk insurers, upon payment of the relevant claim, become subrogated to the owner's rights against the time charterers for the assumed breach of clause number 2. My lords, this result would no doubt be highly attractive to war risk insurers, but the less fortunate time charterers would have paid the premiums not only for no benefit for themselves, but without shedding any of the liabilities which clause 2 would, apart from clause 21, impose upon them. And when you read that, you have a lot of sympathy for the time charterer who's paid for the insurance premiums and then doesn't get the benefit of them. And then you go further down, and so at that stage, I'm thinking, this insurance code makes a lot of sense. And then you read further on, and you get Bingham's contrary view, which says that there shouldn't be a principle exempting the charterers from liability for their breaches of contract merely on the ground that they have directly or indirectly provided the funds whereby the owners insured themselves against such damage. Then he goes on to say, I see no difference in principle between the case of a charter party, wherein the charterers agreed to pay by way of hire $3,300 per day, leaving the owners to bear inter alia the cost of the vessel's insurance amounting to $100 a day, and the case of a charter party wherein the charterers have agreed to pay hire of $3,200 per day, plus the cost, $100 per day, of the vessel's insurances. And then I read that point and I think, that's a very good point too. And actually this insurance code doesn't really stack up. It's kind of fascinating to read through these arguments, and on balance, I think that the court should be very reluctant to find a insurance solution, this insurance code agreed between the parties, because as you said at the very top of this podcast, it disrupts the pricing of the insurance, and it shouldn't be something that the parties have kind of should be readily found to have agreed. But I do see this as almost going to a real point of principle, as opposed to being a kind of legal test where you can apply these criteria and see if it hits A, B, and C, and D.
Yeah, I think that's really interesting how you frame that, Callum. Touches on a thought that was going through my mind when I read through this. And that's kind of stepping back for a moment and just thinking about the development of the common law. I know that's a very high place to start, but this is a really interesting case in the sense that we're dealing with a legal principle or a legal issue here that hasn't actually had that much airtime before the courts. What's fascinating is to see how the most senior court in the land in England deals with a developing line of argument, and how precedent builds on some cases, how other cases are distinguished. Some relevance is drawn from a case that touches on it, but doesn't really go to the point. And I think it's a really good example of how the English courts find a way of navigating through decisions that have gone before, giving them deference wherever they can, giving them applicability, not just throwing them to one side and saying, well, this is a new case, I'm going to decide it afresh. So building on the EVA number 2, then using the Ocean Victory. And let's be frank, the Ocean Victory on this issue was a split decision. So it wasn't a settled issue there, even though that was in a joint names insurance scenario, which is the clearer example of where an insurance code may arise. So the court have then gone back to an 80s case with the EVA number 2. It read a little, and I mean this with deference, of course, but it did read a little formulaic in the way that the court was very clear to go through the EVA number 2 and distinguish it on point 1, 2, 3, 4. And I thought that was an interesting approach. And I think it's kind of going to what I'm saying, that there is a decision that's on point to some extent. Let's use that as a base, and through that, prism, or using that as a base or a stepping off point to look at this new case, which is not exactly on point. Do we follow that? Is it analogous? Is it a point of precedent? Or can we distinguish that? And for those reasons, we put it in a different category and we come up with an alternative outcome because it is distinguishable. This feels like an area of law where the court could, especially, the Supreme Court looking at this issue squarely, start to develop its own principles anew, if you like, or really restate them afresh, because it is such a kind of, untouched area, so to speak, rather than, okay, we've got the EVA number 2, we're going to just go through and distinguish it from that. And I'm not saying that's what the court only did, but it read a little bit like that. I think the best place to go for some overarching kind of principles that came out of this case, and a short snapshot, is in the application of the law to the Charter section, starting at paragraph 57. The court, and I'll say these quickly, states that 1, general average is a common law right. 2, to establish that the parties have agreed an insurance code or fund, it has to be shown that this is a necessary consequence of what has been agreed, and that is a high threshold. It's a point that you've made already, that you don't find insurance codes easily. It's a high threshold. And this case is not a case of joint names insurance. If it had been, it may have been easier to find an insurance code. It's not. So it's more likely that there's not going to be an insurance code. So we've got to look more closely. And then fourthly, there is no principle exempting charterers from liability for their breaches of contract or in general average, merely on the ground that they have directly or indirectly provided the funds whereby the owners insured themselves against the relevant loss or damage. And that's kind of the stepping off point for the court to then go in, as I was just saying before, and look closely at the EVA number 2 and distinguish it.
I had a similar sense to you when I was reading through it. Almost the EVA number, the strict application of the EVA number 2 almost threw me. I was okay. We've had this kind of high level discussion of legal principles and policy. The step by step approach was slightly odd. Maybe it's worth just quickly touching on it though. These are the 4 points that were particular features of the Charter and the EVA number 2 that were helpful to the parties arguing that that the insurance was a complete code. The relevant clause gave an unqualified right to refuse to accept orders for a ship to go or to continue to any place or on any voyage to be used in the service which will subject her to any of the dangers to which the subclause referred. So if the war clause said the owners have an absolute right not to go through the Gulf of Aden, for example, then that would be helpful.
Did you also get the sense that this was given almost such a high priority in the analysis, that if this didn't exist or did exist, it kind of flowed on the result one way or the other?
That was the I guess the itch at the back of my head with this was, is it that important? Are these features of the Charter and the EVA number 2 that important to the kind of legal structural question of is there an intention here to have a complete code of insurance where the recovery is only from the insurance proceeds? Because it seemed to me like the EVA number 2 is perhaps an example of a situation, a rare situation where this might arise. It's not like this is what you need to create a complete code to create this complete insurance code. It's just this is an example of where it's happened before.
And I think the reason I had that sense, Callum, is that even on this point as to whether there was an unqualified right or absolute veto, it wasn't clear cut. It was basically the owners taking on, or the owners and charterers, but the owners taking on the obligation to sail a certain way through the Gulf of Aden overrode what was in the Gulf of Aden clause. This wasn't an unqualified right that was written in plain writing. It was almost a knockout of what was written in plain writing. And so for it to turn on that, and I'm not saying it did just turn on that, there's much more in this decision, but as I read through it, it seemed like that took on such importance in the way, in if you like, the direction of the tide in this case.
Yeah, I had the same thought. And you then get into this question of, this is actually what precipitated the discussion on whether or not there's a requirement for a change in circumstances. Because then, just for the benefit of everyone who's not kind of read the case in detail, there were two clauses under which charterers were obliged to pay these insurances. One was this Gulf of Aden clause and one was a war risks clause. And when you're looking at the question of does the owner have this unqualified right to refuse to accept orders, it then became material whether or not the insurance had to be paid under the Gulf of Aden clause or under the war risks clause. Because that would give you a different answer to the question if it was either or both of those clauses that were triggered. And then that led into this discussion of, okay, well, do you need a material change in circumstances from the war risks on the date that the charter was agreed versus the war risks on the date that the vessel is set to sail through the war risk zone? It does end up on this, quite detailed, lengthy, enjoyable discussion. It just seemed hyper focused on trying to see what happens if you superimpose the EV number 2 on this slightly different fact pattern.
Yeah, which was ultimately distinguished.
Exactly. I think the reason is that obviously the law lawyers have to give due deference to the previous decisions, of course.
Did you want to say more on the insurance code point? I know there's more in there, but were there other points that were jumping out at you that you wanted to make?
I would just summarize that on a high level to say that it's a difficult bar to pass if you to try and argue that one of these insurance codes exists is going to be very difficult with this authority. Rightly, I think it shouldn't be something which is easily read into a contract. Yeah,
I agree with that. I also, my kind of practitioner's point on this case, or at least on the insurance code point in this case, is that a lot of this can be dealt with by contracting. If insurers want to maintain rights of subrogation, they need to ensure that the contracts underneath them that they're insuring maintain those rights. There's quite an important point here to, as I said at the outset, to ensure that charterers, if they want to maintain this ability, maintain that liability is flowing through, even if there's some insurance put in place above them, so that they can maintain their claims down the line. And so I thought this after the Ocean Victory, and I remember saying it to some clients at the time that actually what this does is it really shines a light on areas of charter parties where you might not give much attention to them, and how they sit with insurance. And actually, through the contracting and revisiting some of those clauses with this case sitting next to the contract could be a task worth taking.
And I had the same thought coming out of the Ocean Victory, and it felt massive for the insurance industry. I don't know whether actually the result was quite as big as it felt reading the case, but it's the same. It's the same point here. Is you just have to be very careful as an insurer to see what you're insuring, to make sure you're not insuring something where you've effectively lost the right to subrogate.
So, Callum, should we just touch on the second main issue in this case, the incorporation of charter party provisions into bills of lading? I don't think we need as long on this. These are principles we know well, or should know quite well. It's always good to go over some of these for our listeners and to kind of recap them. And the court here does a great job of doing that. Indeed, kind of chuckled when I read the comment here about there's a large body of case law relating to the incorporation of charter party terms into bills, and there's abundant citation of authority that was presumably put in by the parties, and the court says, well, we don't actually need that much on relevant principles. And then the court says a helpful and succinct summary of the relevant principles is to be found in Scrutton on charter parties, and cited by one of our favourite Lord Justices, Males, in the Court of Appeal, and goes on to quote at paragraph 77 in this judgment, the Males section. So I thought that was a neat one, that sometimes just overloading the court with authorities on what's pretty well-known law is not the way to go.
Yeah, exactly. I thought that was quite funny too. Gave me a wry smile. Good to see our favourite Lord Justice Mills getting a nod from the law lords. Just to explain why this point came up in this case, if it were the case that as between owners and charterers there was this complete insurance code, then obviously the cargo interests, who are the ones who are looking at down the barrel of this GA claim, they would want the benefit of that clause to be incorporated in the bill. So that's why this incorporation of term point comes up. Really, the question is, if you take the clauses by which there is said to be this complete insurance code, do those clauses find their way into the bill by the general wording incorporating the voyage charter?
The discussion we had on the insurance code, that was based on looking at the voyage charter. So those were terms sitting in the voyage charter, and the way that this bill was constructed is that it incorporated, the bill of lading incorporated the language from the voyage charter party into the bill of lading. And as you're saying there, Callum, the question is, what does the incorporating language say on the bill of lading that's pulling in these charter party terms? And is that language sufficient so as to bring in the provisions that deal with the insurance code, if there were one?
The first point, which is mentioned here, which is the critical one. What really matters is the words on the bill incorporating the charter, not what is in the charter dealing with incorporation. So what you need to look to first and foremost is, what does the bill say about incorporation? I don't know if there's much to discuss around that, Luke. It's just if you're trying to work out how much has been incorporated into the bill of lading, you look to the bill of lading and look at how broad the incorporation wording is in the bill.
And where the intention is doubtful and it's not clear whether the language, the specific words of incorporation to pull the charter party provisions in, then the court will not hold that term is incorporated. Moving on to the second point, if it is found that the incorporating clause is wide enough to affect what we're calling a prima facie incorporation, the term which is sought to be incorporated must be examined to see whether it makes sense in the context of the bill of lading. If it does not, it must be rejected. This is where you're performing this, I call it an intelligent, not a mechanical approach. It shouldn't kind of flout common sense, but it's looking to see where the term relates to shipment, carriage, or delivery. And if it does, then, it's the prima facie view is that it does come in, and some degree of manipulation of those provisions is allowed to make the words fit the bill. So, if you're bringing in language that's between owners and charterers from a charter party that deals with shipment, carriage, or delivery, the types of things that you would expect to be in a bill of lading, then the courts allow some massaging, some manipulation of the charter party language to give it some sense in a bill of lading context when you're talking about carriers and shippers and carriers and consignees and carriers and proper holders of the bill.
It's a good point, yeah, because you often see these clauses that deal with owner, charterer, and you can massage that to owner, bill holder, etc. The second key principle here of incorporation is that the bits that will be incorporated, the bits which are germane to shipment, carriage, and delivery of the goods. I guess what's critical there is that if you incorporate the charter party, you don't necessarily incorporate the charter party wholesale. There'll be parts of the charter party which are not relevant to a bill of lading. So what is typically incorporated, if there's broad words of incorporation, will be the terms that are, as they say here, germane to the shipment, carriage, and delivery of the goods.
Yeah, and I like the comment there about what does germane mean. There was some debate about whether germane is archaic language. Again, the court didn't like the suggestion that language that had been used, albeit many years ago, is now out of date. That doesn't resonate with the court. It just highlights again what we're saying about the nature of the common law system. But they did say that, look, if you wanted another phrase for this, directly related is probably directly related to shipment, carriage, delivery is another way of saying germane. I don't know if you picked this one up, Callum, but I also enjoyed the quote here from the Mail's decision, which it was more on the prior point than the germane point. When you're construing contracts, particularly in this kind of situation where you have like a prima facie or provisional view on whether a term should be incorporated or not, or then manipulated into the contract in a way that makes sense, you should always kind of stand back at the end of the process and say, does this make sense? Like, I just thought it's just such a great Lord Justice Mayles type comment. And to see it being picked up by the Supreme Court here, it's not surprising for me, but it's kind of what we say regularly, isn't it? That if you go through this formulaic process and you think, okay, yeah, provisionally, I think this clause should go in, but you then stand back at the end of the process to test that conclusion against the terms of the contract and business common sense. And I think that was a really neat kind of point to include.
I totally agree. And you see it so often with contractual cases and contract law and commercial law generally. It really strikes me more and more that what the court is trying to do is to imply broad, common sense principles. And when I say common sense principles, I'm not talking about an interpretation argument that favors commercial common sense, but I'm talking about looking at what the parties have written and understanding it in a way where it's, commercially reasonable, or at least in a way where you can say it's more about saying, oh yes, that's what they meant, that's clearly what they meant, rather than perhaps the law school approach to law of saying, oh well, if you can really play around with this comma, then this whole sentence will change, and then that will mean this and that'll mean this. The way that these contracts are interpreted is often with that broader view, looking at the entire commercial, contractual matrix, all of the contract taken together to understand each clause. In that way, although you stick to the kind of literal interpretation of contracts, rather than the broad commercial interpretation of contracts, you end up in a much more, I guess, common sense or just commercial sense perspective, because you really benefit from the context of the agreement.
Yeah, exactly. And look, ultimately in this section on whether the Gulf of Aden clause and war risk clause were germane or not, I think the court, it was pretty clear they agreed with the judge and the Court of Appeal, the clauses that are relating to the route to be taken by the vessel and were directly relevant, germane to the carriage. That did pull in the regime. It wasn't a matter of pulling in the regime in kind of bits and pieces. It all comes in. It's all clearly germane to carriage.
There were a couple of other final points, but I don't know if we really need to touch them, because the case was determined by the first issue. There was no complete code of insurance, so there was nothing for the cargo interest to benefit from, even if incorporated into their bill of lading. Look,
there's some other points there which listeners can go and delve into if they want, but we've kind of touched on the main ones there, Callum. It was a enjoyable talk. I hope those listening in have enjoyed it, and thank you for getting this far, and thank you for listening in to another episode of Case by Case. We've got another one coming your way, and quite a different kind of topic, so we hope you like that. Until next time, take care. See you, Callum.
Thank you, everybody. See you next time.